A married couple has significant advantages over an unmarried couple with regard to estate taxes and distribution of assets. So, when you're contemplating whether it makes sense to be married or not, if you're looking at it from an estate planning perspective, it almost always makes sense to be married over not married if you're in a couple relationship. So, on today's episode, we'll discuss these advantages of married couples with regard to your estate planning. So let's get to it. First thing to talk about is inheritance rights. So if you're a married couple and you die without a will, there's statutes in the state of Washington that allow you to receive your share of the estate, right? They dictate where everything goes.
You are listening to the Legacy Talk podcast hosted by James A. Jones,
attorney at law and founder of Sound Legacy Law, PLLC in Tacoma.
Attorney Jones is here to talk about how to best protect your family, assets, and wealth, pulling stories from his more than 20 years of helping families and business owners protect their assets, create their estate plans, preserve their wealth, and plan for the future. Nobody wants to think about estate planning, but life has a way of sneaking up on you, and at any moment, something unexpected could happen that will leave you regretting not having acted sooner. So join Attorney James A. Jones in the Legacy Talk podcast and together learn how to plan for your future today and have peace of mind tomorrow.
Welcome to Legacy Talk. I'm your host, James Jones. I'm an estate planning and probate attorney in Tacoma, Washington. I've been practicing for over 20 years, and my main practice areas include estate planning, probate, and estate administration. On Legacy Talk, we discuss topics surrounding families and estates. Estate planning is often a confusing and complicated topic, but my goal with this podcast is to make it understandable and accessible to those who need it. So if this is something that interests you, I'd appreciate it if you click the subscribe button and like this episode so that you can follow along as we break down the barriers to estate planning. I'm excited to get to today's topic as always. Today's topic is Till Death Do Us Part, the legal advantages of marriage and estate planning. Because being married is a significant advantage to your estate plan. So on today's show, we're talking about Till Death Do Us Part, the legal advantages of marriage in estate planning. So let's get to it. Seems like fewer and fewer people are getting married these days. They're opting instead to be together as partners, foregoing the traditional norm of having a marriage to start a family. Till death do us part isn't what it once was, unfortunately. But whatever the reason for that, there are still good reasons to be married. Outside of the family stability and the relationship advantages, marriage is a significant advantage in estate planning. A married couple has significant advantages over an unmarried couple with regard to estate taxes and distribution of assets. So when you're contemplating whether it makes sense to be married or not, if you're looking at it from an estate planning perspective, it almost always makes sense to be married over not married if you're in a couple relationship. So on today's episode, we'll discuss these advantages of married couples with regard to your estate planning. So let's get to it. First thing to talk about is inheritance rights. So if you're a married couple and you die without a will, there's statutes in the state of Washington that allow you to receive your share of the estate, right? They dictate where everything goes. And so if you're a married couple and your assets are community assets, which means they're assets that you acquired together during the marriage, 100% of those assets go to the surviving spouse by operation of law. And so if you don't have your will done, you still have the ability to receive everything that you would have received had a will been done that says, give everything to my wife or husband. And so through intestate succession laws, you're protected. Alternatively, if you're in a partnership relationship where you're not an officially recognized entity for relationship purposes, you could be a domestic partnership and have some of the same rights here in Washington. But if you were just together without law behind you, that surviving girlfriend or boyfriend, as far as they see it, would not be entitled to anything if there's no estate planning or will in place. And so the first thing, automatic entitlement under intestate laws gives marriage a win. Okay. The second thing to consider is estate taxes. So Washington allows that there's an unlimited marital deduction. Washington and the federal government have an unlimited marital deduction for money or assets that you receive from your spouse via their passing. Okay. So you can receive as much as you want without having any estate tax issues on the first passing. If this isn't in place, if there's not a marriage in place, then would be tax if there was a taxable estate for the first passing. So this allows you to shelter assets, to do more planning down the road. And it's an essential strategy for minimizing taxes with married couples, for sure, that they have this limited marital deduction. Now, on the same context of estate planning, there's an estate planning tax, right? An estate tax, I should say. There's an estate tax in Washington. There's an estate tax at the federal level. And so under the federal estate tax, you can have a portable exemption, which means you can take up to $13.6 million, which wouldn't be subject to tax in your estate under the federal estate tax, and preserve that basically until you die. So if your spouse dies and you don't do any sheltering of that credit, under the federal exemption, you can port that to yourself, basically say, hey, I'm going to save this for later, basically. In Washington, though, that exemption is not portable. And so in Washington, when your first spouse passes away, there's an unlimited marital deduction. But if you have a marital estate plan, you've set up a bypass trust or a credit shelter trust to hold the deceased spouse's exemption. And so that allows you to preserve that exemption, which is $2.193 million, and make sure that's not part of the survivor's taxable estate. Number 4 thing to consider with regard to advantages of marriage over not marriage is joint tenancy and community property rights. In Washington, married couples have access to something called a community property agreement. Washington is a community property state, which means assets that you acquire during marriage, like we just mentioned, are community property. So that means they're both of yours, right? And so Washington, being a community property state, says, well, if you have community assets, you can have what's called a community property agreement. And under a community property agreement, those community assets would immediately pass to the surviving spouse without having to do an additional will or without having to do a probate or anything like that, or a trust, just because you have that agreement. And so it works for real estate, it works for accounts and all kinds of things. So no probate would be necessary. So it's a real big advantage. Also, you don't have to worry about how your deed is designated. So under community property agreement, you don't have to say, I have this property with joint tenants with right of survivorship, which basically means that when one joint tenant dies, the other one gets it. You don't have to worry about that. With a community property agreement, you can just hold it as tenants in common, which is typically how people hold real property in Washington. Number 5, simplified probate and estate administration. So going back to the community property agreement, if you have the community property agreement, you're not going through probate at all in most cases. If there is a need for probate and it's a surviving spouse that would be in charge or the beneficiary, the courts are a little bit more easy to deal with regard to getting an executor appointed if the surviving spouse is the executor, especially if there's no will. If there's no will and the surviving spouse is the executor, the state law says that the surviving spouse doesn't have to post bond, whereas a kid might have to post bond, or a friend or neighbor would have to post bond potentially with the probate. Also, they wouldn't have to have intervention powers of court. So the court would stay out of their way, basically say, tell us when you're done. We won't have to have approval for every little thing. So it makes it easier on the probate side as well. Number 6, Social Security and pension benefits. Surviving spouses in Washington are entitled to federal Social Security survivor benefits, which are potentially crucial for survivability and stability, right? So basically what that means is if you're a married couple and your spouse dies, if your spouse had a better Social Security rate than you, so if you're weren't the primary working spouse, then you could get the deceased spouse's higher rate. Okay. Also, surviving spouses are almost always entitled to pension benefits, whereas if it's not a marriage or domestic partnership type relationship, partner that's just a partner in name only is not eligible typically for those kind of pension survivor benefits, even in long-term partnerships. Number 7, healthcare and financial decision-making rights in Washington. Under Washington law, a spouse is generally given priority to make healthcare decisions for a spouse if they're in a critical condition, incapacitated condition, and there's no healthcare directive or power of attorney in place. Even though power of attorney should be the route to go here, you should have a power of attorney. Don't rely on this law because it's not always followed. If you're in a hospital setting, I know for sure, you want to make sure that you have a power of attorney. But if you don't, you should be okay in an emergency situation to help sort of make decisions for your spouse as a married couple. Whereas if you're in a partnership or non-marriage or non-domestic partnership, then that wouldn't be the case if it's just a partner non-legally binding. Okay, let's see. Number 8 would be community property rules in Washington. So that goes back to 50-50 ownership. And so anything acquired during marriage would be community property. And that provides protection for the surviving spouse. So this is a scenario to consider. If you're a married couple and it's a second marriage and each of you have kids and there's no will, the community property statute right of community property in Washington, it being a community property state, says that under the intestacy laws, which are the laws that say what happens when you die without a will, which we just talked about, say if it's community property, 100% of it goes to the surviving spouse. If it's separate property, which means property that you had before you got married, like a house you had before you got married or investments that you kept separate that were from before you got married, those say in those intestacy laws that 50% would go to the surviving spouse while 50% would go to any children from a previous marriage or relationship. And so if there's children and there's no will, at least the spouse will get half of those assets considering the state laws. If there's no marriage or domestic partnership of record, the surviving partner gets nothing. That's another protection. Another thing that is available for a surviving spouse that's not available as easily, at least, for a non-married partnership is the elective share rights. So if omitted spouse basically is what it's called, which basically says that if a surviving spouse is omitted, like husband dies, doesn't include the wife in the will, and the will says, don't give my wife anything, the wife can petition the court to say, well, I want my omitted spousal share, which gets them basically their community share in the assets, what they would have received if there was no will. And so that protects them as a married couple. That's potentially possible through litigation if it's not a marriage. If it's a marriage-like relationship, it's possible to get some of that, but it's much more complicated when it's not a spouse. And then the other thing that's a benefit to married couples that isn't available for non-recognized, legally recognized partnerships, we're getting there, we're calling it the same thing, non-legally recognized partnerships, that's what we'll call it, okay? In Washington, married couples can utilize sophisticated planning tools like qualified terminal interest property trusts, which can shelter money for the use of a surviving spouse, qualify for the marital deduction, but still pass to kids from a second marriage or kids that a previous spouse wants them to go to, like the first spouse to die has kids from another marriage, or he or she wants to give the assets a different way than his spouse, then those assets would go that way after the surviving spouse has the right to use the income from those properties during their remaining lifetime. You can do a spousal lifetime access trust, which is a way to maximize your estate tax credit by creating a trust for your spouse and gifting your exempt amount of the estate tax to it. In Washington, the estate tax is so low that this is sometimes a good strategy to use. And so those kinds of strategies that are available to married couples where they're not available to unmarried, non-legally recognized partnerships, got it that time, are much more advantageous. So that brings us to our story time. And I just met with this client about a month ago or so. I met with the client, a surviving spouse, a widow, and she came in with her daughter, and they wanted to do estate planning now that her husband had recently passed. And when I hear that, typically, I'm like, well, do you have anything in place now? Well, we had wills, but that's it. And they had a piece of real estate, a house, and they had other accounts and everything. And I said, well, we want to make sure that the estate is passed simply to my remaining beneficiaries when I die. This is what mom says. So we wanted to do a revocable trust, which avoids probate and it makes it a lot easier to administer. The problem was that there was a house that was not in a trust, and there was potentially an issue of having to go through probate to clear title. And like I mentioned before, the probate would have been pretty simple because the surviving spouse would have been able to be appointed without court intervention, without bond, but it would still be money and time and hassle. And so we try to avoid that if we can, right? And so thankfully they had a lawyer draft their will previous. Okay, so when I see a will that's been drafted by an attorney and it's just a will, and there's usually a power of attorney sticking around with it and probably a healthcare directive, which you want to have all those things, I say, well, go back and look. Do you think there's anything there like a community property agreement? And so if there is a community property agreement, then like we mentioned before, you wouldn't have to go through probate to clear title to that house. or accounts or anything like that, because the community property agreement says everything that we have is community property, and then when one of us dies, the title in those assets immediately vests in the surviving spouse. And so I said, go double check, look again, because most people don't know what they're looking for, because the community property agreement is like 1 or 2 pages. It's such a small document, and it's not something people are even familiar with, even though a lot of them probably have one if they have a simple will plan and had a good lawyer draft it for them. Anyway, I sent them home and said, well, we might have to do a probate, and then we'll do the trust. So we'll do the probate, clear title, then put the house in the trust so that there wouldn't be a probate when mom died again. And so we sent them home with some homework, take a look, scour those file cabinets, make sure there's nothing in there. And turns out, after digging and digging, they found this community property agreement. And so with this community property agreement, which we took to the county and recorded with the real property records, basically says, hey, when I die, give everything to my spouse without probate. And so we avoided a probate, which saved them probably $7,000 or $8,000 and about 6 to 12 months of time. And so we were able to do the trust without having to worry about clearing title first through a probate mechanism, because we cleared it because of the community property agreement. So that's a story for you with regard to the community property agreement and its effectiveness. And then the other thing to consider too, story-wise, is married couples basically double the amount of money that you can pass to your children and have access to as a surviving spouse than unmarried couples. So if you're a single parent, you only have one exemption, right? And if you're an unmarried couple, you can't give everything to the surviving partner under the marital exemption. It doesn't work. And so that's a huge advantage, tax planning wise too. So the bad story, I guess, in this scenario, other than what I just mentioned, is I meet with clients all the time where a longtime couple, this is a couple that's been together for years, they've got children together, they've got pretty much everything in common, but they never did get married. And Washington doesn't have a marriage statute, common law marriage statute. I couldn't think of the word. Washington does not have common law marriage. And so these couples, after 8 years, aren't considered married like they are in some states. And so there's issues with their inheritance. There's issues with the wife who has little kids sometimes. I had a client who was a young mother who lost her partner. They had 2 young children. I may have mentioned this in another episode, but there were real estate to deal with, and the kids were minors. And so mom had to do all this work. She didn't get anything from it. It went to her children, thankfully, but she doesn't have anything for herself. So because of poor planning, they didn't have anything in place. And so it also can help with that. If you're married, that wouldn't have been an issue. She would have gotten everything. She would have been able to deal with it herself, not have to do a lot of stuff with the courts because of minor children. And so that's the bad, right? So if you're thinking about getting married, if the only reason that you're getting married is for estate tax purposes or estate planning purposes, maybe that's it. Maybe that's the reason. So that's it for today. But I do have something good this week. Something good segment going now. So according to Como News, the Seattle Aquarium's long-planned and long-awaited Ocean Pavilion is now officially open and renewing hopes that it will serve as a spark plug for downtown. So since COVID, downtown Seattle's been kind of run down like a lot of major cities in this country. There's a homeless problem, there's increased crime and all this. And so they're trying to clean it up. Continue. $160 million project is part of a massive waterfront makeover that began in earnest with the seawall replacement and viaduct demolition. So they've got rid of the viaduct, cleared out that whole space. It says, while other parks and piers have opened, they pale in comparison to the expectations for this one. The aquarium's roof is part of an overlook, complete with seating and stairs that will be connected by a pedestrian overpass to Pike Place Market that will open in October. And according to the aquarium CEO, Bob Davison, it says, it matters on many different threads. They've been planning this for 20 years. This is a primary cultural attraction, and the entire downtown is right here. And people will come from all over the world to see it. Seattle's a beautiful city. When I first came to Seattle in the late 90s, I immediately loved the place. Like, it was clean and nice. It's gone down, honestly. It's gone down like many cities in this country, unfortunately. But the waterfront, now with the viaduct gone, and they're cleaning it up. My family and I were up there a few weeks ago, and it's a completely different spot. Like, it's such a nice place to vacation and see. So hopefully they can clean up, they can continue to keep moving forward as far as the cleanup there goes, and more people can enjoy it. But that aquarium Ocean Pavilion. Looks pretty cool, actually. So if you haven't looked at it, check it out. So that's it. That's the episode for today. Thanks for listening to today's episode of Legacy Talk. If you liked today's episode and would like to learn more, please like and subscribe for more great content. I've been your host, James Jones. To your legacy.
Thank you for listening to the Legacy Talk podcast by attorney James A. Jones. If you found today's episode helpful, we ask that you like and follow us on all major platforms so you don't miss out on the latest episode. If you have questions for Attorney Jones, reach out at info@joneslegacylaw.com or visit our website at joneslegacylaw.com. Join us again next week for another episode of the Legacy Talk podcast.